The Ninth Circuit Court of Appeals ruled last week that the Maricopa County Sheriff's Office acted unconstitutionally in posting the mugshots of people who've been arrested. The court ruled that posting such photos amounts to punishment before an adjudication of guilt. Joining us now to talk about the ruling is Stephen Montoya, partner at the law firm Montoya, Lucero and Pastor. Good to have you here. Thanks for joining.
Thank you.
What did the appeals courts rule here? Give us a broad definition, and we'll kind of dive in from there.
I don't think it was a very surprising ruling. I think it was applying settled law. The Eighth Amendment prohibits cruel and unusual punishment. I guess the archetype of cruel punishment would be to punish someone before they've been adjudicated guilty. Punishment can include public shaming. That's a very ancient form of punishment. That's what was happening in this case, unfortunately. Under the administration of the former sheriff of Maricopa County, Joseph Arpaio, mugshots of everyone arrested were put on a website and kept there for 3 days, available for the public, available for other entities to copy and disperse however they pleased. Many of those individuals, in fact, thousands of those individuals, were never formally charged with a crime, were never convicted of a crime. Some of them were completely exonerated by law enforcement agencies before they were even charged. But nevertheless, they were published, their mugshots were published as criminals, and they were humiliated. It hurted their family, it hurt their family lives, it hurt their public lives, it hurt their professional lives. And the Ninth Circuit concluded yesterday, unanimously, that violated the Eighth Amendment's prohibition of cruel and unusual punishment as applied to the states by means of the 14th Amendment.
So due process obviously at play here, the idea of public exposure and humiliation before being found guilty of anything also at play. This made it to the appeals court because somewhere along the line, a judge somehow ruled that it wasn't such a bad idea. What was the reasoning there?
Well, the reasoning has some traction. Public records are admissible or are open to the public under the Arizona public records laws. So if you want to see who was arrested, that's a public record. You can go look. Their mugshot is part of the public record. So the theory was, well, if it's part of the public record and public records are open to everyone, why not publish it on the internet? That was the theory, at least.
Okay, so, but is there a way to encourage transparency in the judicial system and in the law enforcement, justice system, if you will, without going so far as to put these faces out in public on the internet?
The court concluded affirmatively to that question, yes. And here's how you do it. Hey, if a reporter or a private citizen wants to go to the Maricopa County Sheriff's Office and look at the mugshots and look at the record, they can. But they're not going to put it on the internet.
I see.
And they're not going to release it to the public at large.
So, okay, not to release it
to the world.
Well, let's say that everyone wants to know who this person was. It's a big story in Phoenix, and someone's been arrested. We want to see what this person looks like. Does the public have a right to know, or does the court say, not until adjudicated?
No, the public has a right to know if they go look at the records themselves. However, the Maricopa County Sheriff's Office doesn't have the right to publish their pictures and their date of birth, their height, their hair color, their eye color, to the world, to the people in to the people in Russia, China, Timbuktu, all over the world.
Do they have a right to distribute that information to the media?
Not the mugshots. I would say no. I would say that the press has the right to review it, but not to copy it and disseminate it. But that's a question that's going to have to wait for another day.
Another case, right?
Yes.
Is there any precedent for this kind of thing?
Yeah, there was a case that was decided in 2014 called Demery versus Arpaio. Because remember, Sheriff Arpaio used to have webcams in the jails.
Yes.
That would film people who were under arrest but could still be innocent. In fact, some of them were absolutely innocent. Some of them were falsely arrested by accident because of mistaken identities. But yet, their pictures were published on TV and on the internet throughout the world, and the Ninth Circuit said that constituted cruel and unusual punishment. in violation of the Eighth Amendment as applied to the states through the 14th Amendment.
So with that in mind, and in this case in particular now, is this over? Is this ball game, or is it going to continue? And how far could it continue to go?
Well, I think it's not over because the claimant, the plaintiff, wants money damages because he suffered. I don't think he's going to get it, and I'll tell you why. Because I think the doctrine of qualified immunity is going to immunize the county and the other defendants, because I'm not sure that this rule that the Ninth Circuit recognized was, quote, clearly established. That's going to be a matter of controversy. And I always say, I practice in this area of law, that qualified immunity is qualified in theory but absolute in fact. Most times the defense of qualified immunity prevails.
Interesting. Maricopa County Sheriff's Office is now not doing this anymore. I think the Gila County's not doing it, Yuma County, Cochise County not doing it anymore.
I checked this morning, it's not.
Okay. Are other counties in Arizona publishing these mugshots?
If they are, it's not going to persist for very long because it's clearly established now, and they'll be sued if they do. I think not.
Well, the last question here regarding all of this public exposure, humiliation of pre-trial detainees. Got that. You haven't been convicted of anything, and you're out there making fun of these folks. How far does public shaming and humiliation go in terms of punishment before it hits cruel and unusual for someone who has been convicted?
I think it goes as far as spite can take it. I don't think there's going to be a constitutional limit on that because, for example, if someone's convicted of rape, child molestation, murder, a lot of shame is going to go with that, and it's going to persist as long as the public memory persists.
Okay, but the shame of the act goes with that, but additional shame perpetrated by some sort of government agency, that's still,
Well,
I guess once you're convicted, that's...
Yeah, once you're convicted, I really think that would be a loser of a case.
Yeah, yeah. How interesting. All right, Stephen Montoya, Lucero, and Pastor. I find these things fascinating. Thank you so much for joining us.
Thank you, sir.